Good afternoon, early evening, everyone. Um, so this is usually not a live at 5 day with Tympanic Law, but I thought I would make an exception considering that it's a lot of been talk about reasonable doubt. People in my mentions nonstop. Oh, that's reasonable doubt. That's reasonable doubt. It's like, all right, we need to discuss this because every single thing that comes up is not just reasonable doubt. Oh, they're not guilty. Oh, how can they get stop? Let's discuss what it really is. A very easy definition. Reasonable doubt exists when you are not firmly convinced of the defendant's guilt after you've weighed and considered all the evidence. So this is what is important about it. After you've considered all the evidence. That means evidence from the Commonwealth, evidence from the defense. After that, if you're not convinced of the defendant's guilt, that's the key. I'll give you an example. In the Casey Anthony trial about 14 years ago, there was testimony from the medical examiner who stated, I don't know how the kid died, whether it was homicide or accidental. That is reasonable doubt because the theory was murder. At first degree murder, it's like if you can't prove whether it was a homicide or an accident, that's reasonable doubt. Here, people are like, oh, the medical examiner couldn't decide. It's like not the same thing because the defense is arguing the defendant was brought into 34 Fairview and beat to death. That's a homicide. Or, as opposed to what the Commonwealth saying is that Officer O'Keefe was struck by a vehicle, homicide as well, or accidental. So they don't know one way or another. So it's not really the same thing. It's like, oh, the Google search. Oh, just wait till Mr. Green. I don't know if that's as strong of an argument as people think. Mr. Green is not in the same category as Miss Hyde, realistically. And when Hank Brennan's done, nobody's going to remember what Mr. Green said. They're going to probably dismiss it. So, like I said, what is reasonable doubt? Very, very simple. It is not a mere possible doubt. It's not, oh, well, why didn't Jennifer McCabe do this? Or why didn't Kerry Roberts do that? Or why didn't Brian Albert come out of his house? That's a speculative doubt. That's an imaginary doubt. That's a forced doubt. That's not a reasonable doubt. A reasonable doubt would require the pieces of the taillight were not there. That would be possible reasonable doubt, as was, oh, well, the expert for the Commonwealth says, I don't know if it was a pedestrian strike. That would probably be reasonable doubt. But everybody just saying every little thing, oh, it's reasonable doubt. It's littered all over the place. Like, you can't do that until the case is over with. Oh, for those wondering, I'm wearing, the Miranda v. Arizona shirt that I got at one of a criminal defense conference. And the holding, and what it says below, holding, shut the fuck up. And the reason why that's important is I'll give you an example. I had two clients this week. One who had confessed to possessing marijuana and everything. It's like, did it all on video saying smoke it. She was taking the rap for her cousin. The problem is the moment she did that, they stopped investigating. She was originally charged with 2 felonies. I got her 2 misdemeanors. She wasn't even convicted. And that's because I tuned up the prosecutor on Monday. It was awesome. But if she had not said anything, she wouldn't have been convicted. I would have gotten her case dismissed. As opposed to my other client who was arrested last March for drug trafficking. Over 400 grams of MDMA. A lot of drugs. 15-year min man. He didn't admit to anything. It's a constructive possession case, jointly occupied, nothing. Today, he walks. No charges. No, they were dismissed. He was charged, and I fought tooth and nail, and he got it dismissed. What's the difference between the two? One client admitted, the other one shut the fuck up. And guess what? The person who didn't talk is the one who walks. So very important. No matter what you think you're being helpful. If you're under a criminal investigation, you don't speak to police. You're hurting yourself. I guarantee you. Whatever they try to do, they're trying to make the case against you. Don't do it. So back to what we were saying about reasonable doubt. you can't really just say it's like, oh, any ask every question that under the sun. Well, why didn't they do this? Why didn't they do that? How is his head? And it's like, no, that's not how it works. You need to talk about the crime, the reasonable doubt of the elements of murder, of manslaughter, of leaving of the scene of an accident involving serious bodily injury or death. Those are where the actual reasonable doubt is, not just every single thing that is presented is reasonable doubt. And it's not, they're like, oh, it's all over the place. Oh, how could they? I'm seeing people being like, oh, how could they bring this case without knowing that the Google search is like, no, it's been explained about like 5 different ways that a tab was opened by Jennifer McCabe at 2:27 a.m. The search was made at roughly 6:30. At 2:27, she's watching a video of It's Raining Men, which I thought was kind of hilarious. So it's unbelievable. So it's like, what do you guys need? And that's what the jury's saying. It's like, yeah, she's explaining exactly what they want. And yeah, it have to get wordy. It does, because Hank Brennan has to eliminate each and every one of the doubts. And that it could have been, or what if they could have been deleted, or what about this and that, and the software updates. You got to cover all their bases, because if you don't, he knows exactly what Alessi is going to argue on cross. And you don't want an issue. You don't want an issue coming up on cross that you didn't discuss on direct, that you overlooked, because then the jury's like, what about that? You need to cover each and every one of your bases. That's what's so important about directing witnesses and making sure there isn't a reasonable doubt. Because if the Google search is at 2:27, it's like, okay, why would she be doing that? And that would be a question that would be in the back of the juror's mind. Thankfully for the Commonwealth, that's been debunked 6 ways to Sunday. People are like, no, it hasn't. I was like, well, yes, it has, by both Celebrite and Jessica Hyde used like 7 different services to be able to make sure that they were on firm ground. So unfortunately, the people who believe in this conspiracy aren't going to be convinced of anything you say. Do you think the jurors could be getting bothered by the way the defense attorneys are coming in witnesses? Yeah, oh my God. I will say this once and I will say this again. Aggressive crosses aren't allowed, and they're not warranted by juries unless the witness is coming off objectively like a liar and a piece of shit, for lack of a better word. Excuse my language. And maybe Trooper Michael Proctor might be the only person in the Commonwealth's case where they do that. But they're so prepared for the witnesses from the first trial, where they came in unprepared and they came back combative and evasive at times, that they didn't change it up. And that's really weighing on them with the jury. That's like, can you just ask questions? Can you just cross? Like, everything doesn't need to be this gotcha moment that doesn't exist. So, but yeah, the defendant's behavior, like I saw her texting in court. When I try a criminal case, my clients sit there, they get a pad of paper and a pen. They can write stuff down. And I always tell them, if something doesn't go our way, you don't hang your head. You don't look back into the juror. You don't look back into the gallery to look at your family, like discuss. You don't do that. Juries see that. They're looking at you. They take turns looking at you throughout the case. And they're thinking to themselves, is this person capable of doing what they're saying? Is that texting allowed in court? Some judges allow it, some don't, but it's just optically, it's bad. Never text if you're the defendant in front of the jury. Never. It shows you're on trial for murder. You're not texting like, hey, where are we going to dinner tonight? It's like, oh, or do we have another like fundraiser or something like that? Don't do that. It's just optically, it looks bad. And if a jury's saying that, they're like, is she not taking this seriously? What are we doing here? The defendant is not being considerate of the juror's time, because they're giving up their lives, their livelihood. It's not all of them are going to be getting paid. They get paid a few days by their job, few weeks, and then they're on their own. This is an 8-week trial. People have to literally live off their savings if they're lucky enough when they're doing this type of trial. Karen said the defense can be playing the full clip. Are they going to do that without her testifying? Yeah, but there's no like, um, especially 88 Brennan is not providing uncontextualized clips. They're literally just edited down for time because we can play the whole thing. It's not going to change anything. Like today, it's like it's either me or Jen McCade. Either I'm going down or you. That was really powerful seeing that after the Jessica Hyde testifying because it's like shows it's like did the defendant herself just make this whole thing up because she didn't want to go down? Because I remember, I think eventually it's going to be, I don't know if it's already been played or eventually will be played, that the defendant said, John is dead. I can't save him. I have to save myself. So I remember that's in the documentary. I think that's going to be played later. And it just looks bad. It just looks like this whole thing was concocted to try to save her ass. And that's kind of what what Special 88 Brennan's getting at. And I've said this once, and I'll say it again: the documentary is one of the worst decisions I've ever seen a defense team make. Realistically, it was just horrific, and it's just literally the gift that keeps on giving. Can doubt overrule data like the cell phone data and the car data? No. Unless you have people on the jury who don't care what the evidence says and they've already made up their mind, doubt is not going to override data. The data is digitally forensic. Science is scientific fact is fact for a reason. It can't be disputed. So fact, the Google search occurred at 6:30. A tab was open at 2:27. That search did not occur at 2:27. Fact. Opinion would be, no, it didn't. She said it was missing context. I'm not sure context would help her with it. It's just spin. It's just spin. She hadn't spoken in 2 days after she had rough days in court. She's like, oh well, we got to provide context so that's the story, because this has turned into like a media circus. Like Fox 25 has their own tab on their website about this trial. Ted Daniel, Christina Rex have literally made careers out of this case. So it's just like there is no context. It's just spin. For those wondering, I don't think she takes a stand. I think it would just sink her. I really do. And it make great for great TV, but my recommendation would be absolutely not as defense counsel. Especially 88 Brennan would just rip her to shreds, play every clip, have her on the stand for 2-3 days, and she'd be dead in the water. And any kind of doubt would be eliminated. What else? I like what was overlooked today, because we have to what was overlooked today because we talked about the Google search was the taillight evidence. The little pieces of the taillight were shown, and they were found on John O'Keefe's clothing. They were found near his body. Not a taillight, her taillight. And they were under the snow. So it's either one of two things. Either the defendant struck the Officer O'Keefe and the pieces cracked, and they resided exactly where you would expect them to be, a pedestrian strike. Or somehow pieces you can't pick up were planted and thrown into the snow that got in so deep. It just sounds ridiculous. It really does. And I have to think that's kind of where we're at right now. I haven't seen anything to believe that's like, this is legitimate. So that's kind of where it's at. I really think that it's just getting dismantled on a daily basis. I think Alassi has a better bedside manner than Alan Jackson when it comes to crossing, because Jackson seems like he only has one speed, and that's just not the way it works. I know it's not over yet. Curious where you're leaning, Matt. Does Hank get murdered too? I don't know. I do not. I have not. It's going to come with the pedestrian strike and the car data. Until I see that, I can't tell you murder too. Right now, the answer is no. They've made a manslaughter case for me. She's drunk. The piece of the taillight. She's the only one in the area. He didn't go into the house. So I think they've somewhat made a manslaughter case, but you still need the vehicle information. You need to expand upon it. You need to hammer that home. And unless you do, you're not getting murder too. Some free carry want to close based his performance. Would he be better? No, he's not better than Alan Jackson. But he might be able to connect better with the jury. So that's not like the worst take in the world, but he isn't better, but might be better for this case and this jury. What the last both her parents nodding at Jen or me going down. Yeah. That's such a bad clip. It just shows us like this defendant is willing to do anything, say anything, do anything. And it's just the gift that keeps on giving. What does the defense have to listen to their client, and what do they do even if it's not in their best interest? Okay, this is a great question. What does the defense have to do? The defense are in complete control of trial strategy. The defendant handles three things. One, whether or not to testify. That's the defendant's right and the defendant's alone. If they want to testify, the attorney can't stop them. Two, they decide whether or not to take a plea deal. And three, whether or not to fire defense counsel, fire defense counsel. That's it. Everything else is the defendant's own prerogative. So if you don't have client control, your client kind of runs the show when they shouldn't. But if you do, then you have better control of your client. The fact that she's texting in court in front of a jury and doing all this stuff, it's bad. That's like, I'm like, get off your phone. I had a client who brought a Bible in to jury selection on Monday. That's perfectly fine because we were going to argue a false confession. So the jury's going to be like, if someone who believes in this, she can't be a liar if she's one who reads the Bible for pleasure. What about her looking like an attorney and behaving like one? How does the jury see that? Jury doesn't really mind too much because they're going to get instructions. It's perfectly okay for her to like sit there and to take notes and to communicate with her attorney. It's not that big of a deal. Thoughts on the age in the jury? It is said the jury is younger, early. It depends. I don't know the jury's makeup, and they haven't really identified kind of the age of them, really, but more of an older jury probably doesn't dismiss all the evidence presented. Maybe a younger one might, but the evidence has been pretty strong so far. And I definitely think that the whole case, because the conspiracy has been debunked, they're going to try to aggressively cross Brian Albert, Brian Higgins. It's just not going to land. It's just going to look ridiculous. So the whole case is the pedestrian strike. Commonwealth witnesses, defense witnesses. It does not seem like the case right now. What do you think of pulling it and being the only one to talk to him that he goes up and asks the last question? How would you approach defending this case with all the clips? I wouldn't have allowed her to do the documentary in the first place, knowing that it's like, are we just tempting fate? Because if we don't win, these will be used in her retrial. So what is their actual defense? The police work? That's what it should be. But in reality, they're trying this. They want to argue third-party culprit again because they want to give the jury something juicy to consider. Well, what if it was Brian Albert and Brian Higgins? Maybe they were. Stop. But so have you seen a client go up to sidebar? No. The only time a client goes up to a sidebar is if they're representing themselves. It's just because they didn't have the audio equipment set up this time for the defendant to listen in, which is kind of stupid. Yes. Then in the garage, the whole Chloe the dog thing is just ridiculous. It's always been ridiculous. But unfortunately, the people that have been pushing this conspiracy they're not really attorneys, and they're not criminal attorneys who know what reasonable doubt is. They know how to present a case, know how to keep client control. This is what I do for a living. This is why I comment on it. And people are like, oh, how are you a real attorney? I'm like, because my bar card says I am, and I've tried over 40 cases. I know what I'm talking about. I know what I'm doing. And I know what to be looking for. I know what the questions are going to be asked. I know how to cross, redirect, recross, the whole shebang. So I think that's where we're going to leave it for today. Thank you all for coming in. And yeah, with reasonable doubt, know that it's not every single thing that comes in is reasonable doubt. And have a wonderful day, everyone. I'll see you tomorrow at 5.